She's here in the studio with us tonight under the lights that are so bright. Her name is Valerie Lopez, and what you're looking at is a cartoon by bizarrocomics.com, and it starts, "How much is it?" as they stand to the vending machine that dispenses justice. And the guy and the client in front putting his money says, "It varies. You just keep putting money in until you're broke and hope for the best." And with that, I want to introduce you to Valerie Lopez, who's here with me in the studio. I'm taking off my white hat. And also for you viewers at home. Here with me in the studio, I'm taking off my white hat for our audience that's here tonight and also for you viewers at home. What tonight I'm bringing you is another witness, another Paul Revere in the female form, who's carrying the torch for all you people that have been foreclosed on, or you are about to be foreclosed on, or you think you might be foreclosed on, or you've been tricked into what Candace Jones called fraud or modifying loans. She says you can't do it because you're modifying fraud.
They have wonderful little words they love to slip in. And if anyone ever read the TARP, you could know that it was only suggested that they do modification for these people. Now, first off, I don't believe in these modifications because it's modifying fraud, just as Renee said. These documents are fraudulent in everything I've seen over the last 3 years.
And that was on the California 18, which you weren't here that night.
No, I was not.
But I'm glad you're here tonight, and welcome back for your second shot.
My second shot,
Second shot. That America is kind of a banana republic.
Right now it is. It's the wild, wild west.
Are the Congress in charge?
No.
Is the president in charge?
No one's listening to us.
That's right. We have no representation. Who do you think is really running this country?
The people that make the Federal Reserve notes, worthless securities, the people that have access to that magic machine.
To just print money out of thin air and just keep cranking it over.
Just like Bewitched. They twinkle their nose and they create money out of thin air. Those are the people who are in charge.
Okay, so you were in securities brokerage, you had your own firm. Who did you train with? Because most people didn't see this first show.
Okay, well, I began in the mortgage industry in 1987, and I was fortunate to work with very prominent mortgage bankers, Bob Newberry, who ran World Savings Secondary Department, Glenn Pickren, Bob Urey, Dan Dalglazzi, who ran Mission Hills, Sandy Lewis. I ran Sandy Lewis's secondary market. And then also, of course, I bought my own mortgage company in 1995 and ran my own mortgage company, the secondary market as well.
How long did you do that?
Since 1987. I bought my company in 1995.
95, and you decided to quit because you saw the little beginnings of fraud?
In 2010, I actually had to file a bankruptcy. I didn't go into this on my first visit. I was a credit card queen. I didn't use them, but I had credit cards. I thought it was a flattering gesture from the banks. And I was doing business with Countrywide, and one of their employees stole my credit information, and I had credit transactions all around the world.
Wow.
Due to this identity theft. So consequently, I was having difficulty balancing my business plus trying to battle this identity theft. So I thought I would go to a safe haven, the bankruptcy court, to weed through all of this mess. And lo and behold, I got shot right behind on my blind side by a company called PITE Duncan.
PITE Duncan?
PITE Duncan. Yes, it's a third-party debt collector. And
are they warm, fuzzy, friendly people?
No, they're not.
They're like sharks with real double sharp teeth?
They are. Well, their parent company was going down the drain financially. They were headed towards bankruptcy. So they did a reorganization business plan to avoid it. And their goal, their eye on the prize, was to go into bankruptcy court and snatch up as many homes as they possibly could by filing fraudulent documents within the court. And I was one of their victims.
Ah, so you were a victim first, and you'd been in the business.
Right. Yeah, so I knew. I mean,
so you recognized the fraud they were pulling at the time.
Who were they kidding? They weren't kidding me. I knew exactly.
You had your own company for 10 years when this happened.
Right.
More than 10 years. You've been packaging these things together and selling them off to Wall Street.
That's correct. Prior to going to Wall Street, before you go to Wall Street, you have to get your file, your mortgage file, after the borrower signs the package, and make sure that it meets all underwriting guidelines, make sure that all the housing, health and safety issues are met. And at that point then, that package, which entails your paper note with a payment stream or your debt still intact to the paper note, and in your paper deed of trust and any applicable assignments of deed of trust are actually sold and negotiated and transferred all together.
Altogether, the
yeah,
whole package.
Yes, everything. It's a lot of paper processing, and that needs to take place. I always say you walk through the state of California door to take care of all these tasks.
Which requires recording at the county courthouse.
Yes, after each sale.
And you don't leave a blank line.
No. You're going to see everything parallel. So if there is a sale, it's like a pink slip. You don't wait 10 years to file your pink slip. It's done.
Yeah, right away.
Yeah, you have, well, with the state of California laws, you have a temporary secured status for 20 days. Then it's California Commercial Code 9312 says you get that assignment deed of trust filed. Otherwise, there's going to be an unsecured status. And then we'll look at the compliance issues. And in the case that you haven't complied, you're toast. That debt is no longer secured. That debt is no longer secured. That debt is no longer secured. There's going to be an unsecured status, and then we'll look at the compliance issues. And in the case that you haven't complied, you're toast. That debt is no longer secured. That debt is no longer secured.
So if it's not secured, has no more validity than a unsecured credit card debt.
That's correct. Yes, essentially. Well,
the homeowner thinks it is because they're making payments under threat that the big bad bank or the big bad wolf bank is going to come and eat their house and take it away and throw them in the street because they think it's secured because they have not gone back to whoever's servicing their loan and said, I want to see all the original documents. I want to see the whole package all together. Nobody does that.
No. In the case that
But they should, huh?
In the case that if there's someone like me and they recognize that there was illegalities, then you have a right to tell that judge, I have an illegalities defense. And based on that, under 12 CFR 226.39, I want all the accounting. I want all the accounting. I want all the accounting. I'm demanding all the accounting because of all the illegalities that are present. You have a blank line with an unnamed payee. You have missing assignments. Consequently, that proves that this transaction did not follow the state of California real property laws. Which are very important in order to maintain that secured status, the debt secured to the house.
And when they violate that law, is that more than just a civil tort? Is that a penal code violation?
No, at this point, we got to stop saying it's a civil matter. I'm tired of hearing it's a civil matter. This is a federal R.I.C.O organization that is happening. The servicers don't have a leg to stand on. They're just collecting the unsecured payment stream.
They're doing white-collar crime.
Yes, that's
and
exactly.
because they live in big, fancy houses and big bank buildings, and they pay themselves huge salaries to rob people of their homes, they think they're not accountable to the criminal law.
Right, they're better than us. But we have news for them. We're their equals.
At least they're equals.
We're their equals, and they have to answer to us.
Okay, so what are the steps you would recommend? Because I keep looking at this bizarro, comics thing. You just keep putting money in and putting money in until you're broke and hope for the best. And there's lots of people who paid their attorneys and paid their attorneys and then found out their attorneys didn't know what they're doing.
Correct.
And they lost their house. And then sometimes they found out their attorney took some money from the bank in the back under the table, and nobody sees that.
Right. Yeah, I mean, people have to be very careful just because these attorneys will say, oh, I just can't stand the bank. Yeah, right. You just want my monthly paycheck to go to your office. So people have to be very careful. They have to understand the crime thoroughly, because I really feel that when it comes to hiring legal help, you have to understand, the client needs to understand that The attorney is like a chainsaw, and the client is the operator. So it's very important that you understand the crime so that you can direct that chainsaw to work effectively.
Yes, and we'll see how much truth we can get out of them when they're in that position. You know, they used to in the olden days, like 200 years ago, when they caught people doing bad things, they would put them in the stocks and pelt them with rotten tomatoes and potatoes and mud and dirt. Maybe we should reserve that punishment and bring that back just for bankers.
I think so. I mean, I was reading a book. It was called The Founding Fathers on Leadership, and it goes into very personal experiences. And they were talking about George Washington and how he used to, I'm not sure what you call it, but he used to take a paddle to them. Yeah, I think that's what we should do.
So, when somebody gets the note,
this is what I'd like to do.
Okay, do it.
I think that our last presentation was great, but this crime is like the invisible man. I think at our last presentation we put the sunglasses on and the hat on. Let's put the coat and the shoes on. Okay? So what I'd like to do is I'd like to go ahead and put out a few definitions, and then we're going to go into the PowerPoint. Okay? And I'm going to try to keep it as simple as possible so everyone can understand the crime, and there's no excuses. I'm hoping that this goes out to sheriffs and DAs so that we can educate everyone on this crime, because by permitting these crimes, we're only hurting ourselves, and we're never going to maintain our life the way it should be due to this fallen economy. First of all, the banana. I feel that this banana is representative of the paper note. The paper is representative of the peel, and then the inside of the banana is your payment stream or your debt. That's what you send to the servicer every single month. Okay?
The inside, after we peel.
Yes, that is your debt. That's your monthly payment.
The monthly payment is the stuff inside.
Yeah, and then this is your paper here.
This is the paper.
Right.
Okay, so they're peeling the paper away.
Well, not quite yet. Let's not go there, but let's just go and define everything first. Okay, but you get the gist of it. Okay,
yep.
Because you don't see the debt or the payment stream. It's invisible. Okay, but it's an actual item.
Yeah, it's real.
Okay, so we got that. What I'd like to do now is let's define what the state real property laws consider to be a true legal sale. The state defines a true sale to be the sale of the paper document, along with the payment stream still intact, the paper deed of trust, as well as any applicable assignments of deed of trust that are timely. They must happen parallel, meaning if there's a sale...
Same instant, same time.
Around the same time. I mean, you can go ahead and wait 10 days to file the assignment, but usually, I mean, if you're on your game, once the sale has taken place and the seller has agreed to buy the entire paper package, then me as the seller, I'm going to go ahead and do my work, and I'm going to go to the county and record that assignment deed of trust.
Now, let me be clear. We're not talking about a real estate sale end of it where you're talking about the buyer buying it from the seller. We're talking about the paper and the payment stream inside it in that loan package.
Correct, yes.
So when we say the buyer, we're talking about Wall Street or investors within the state or somewhere.
So in the case that you're a buyer, so if a homeowner signs his package, then I take the package, then I prepare the file to make sure I can present it to the next potential buyer of this mortgage package. So it's you, so you would go ahead and take a look at the mortgage package, and we'll negotiate the sale. So then once it's concluded, then I will record what's called an assignment of deed of trust, which is like a pink slip.
Okay.
Which shows that you are now the owner of that lawful mortgage package. It's all paper.
And where do you record that pink slip?
In the county records.
In the county in which the property resides?
That's correct.
Not the county where the bank's head corporate office is?
No, it's where the property is located.
Where the property is. So if they don't find a recording dated within 30 days or so.
It's actually, you actually have a 20-day period. You have a 20-day period where there's a temporary secured status.
So if they don't record it within that 20 days, is that the first felony?
Well, essentially, it definitely could be something negative.
They're cheating the county out of fees.
Oh, definitely, yeah. But let's go ahead.
Okay, go ahead.
Okay, so my main point is I just wanted to achieve, just to define what is a true sale. So you know it's the purchase of a complete paper package.
The whole package, got it.
Everything, all three parts, okay? We know it's the paper note and it's debt, aka the payment stream.
The payment stream, which is inside.
Right,
Yep.
and then the deed of trust, and then any applicable assignments of deed of trust.
And the assignments of the deed of trust.
Okay.
That's the whole package.
Okay. Next, what I'd like to do is go ahead and discuss the MERS Certifying Officer's Handbook. Okay?
First, define what MERS is, because this is a relatively new term. They didn't even have MERS when I was selling real estate a decade or so ago.
Okay, the MERS is actually, it's a database, and it was created by the banking industry for their convenience. It wasn't approved by the people, we the people.
By Congress.
Right,
or anybody.
No, it was not. It was for their convenience, administrative convenience. And what it does is it actually keeps track of who owns the debt,
Okay.
the inside of the banana.
They keep track of who owns the inside, the banana, the
Correct.
payment stream inside.
The payment stream, right. Our monthly
Okay.
payment that we send every month. Okay, so the MERS Certifying Officer's Handbook is the Bible.
There
we go. This is the MERS Certifying Officer's Handbook. And this is the Bible that sets the restrictions of what an assignment of deed of trust should actually represent. Okay, so I'm just going to stop there. Let's discuss what would be a perfect MERS assignment of deed of trust. And we're going to use my loan, for example.
Okay.
My note in deed of trust, the entity that gave me my loan was GN Mortgage.
All right.
Okay. So let's just say GN Mortgage sold it to buyer number B
Okay.
within 10 days of me signing the documents. So a perfect assignment deed of trust would be GN Mortgage to seller number B. Okay, the B party took the entire paper package, and then GN Mortgage made an assignment of deed of trust to company number B, and it's done within a 20-day window.
Okay.
Okay, according to California Commercial Code 9312. So that's been perfected. The debt is still intact with the paper note. That is a perfect assignment of deed of trust. Okay. Now let's take a look at what's not a perfect assignment of deed of trust. Okay, you ready for this?
Ready?
Okay. This is what was submitted to my court and how I knew that this was not a good situation. Okay, here's an assignment of deed of trust. Notice who created this assignment of deed of trust. Recorded, let's see here. Prepared
China
by,
Brown?
well, no, look up here. Prepared by, when recorded, mailed to PITE DUNCAN LLP.
PITE Duncan LLP.
Okay.
Ship and drive.
They're a third-party debt collector. So this is not an effective assignment deed of trust. First of all, I got my loan in 2005. All right. Now, China Brown signed it in 2010.
Oh my gosh.
And everyone knows that China Brown is a Wells Fargo employee. So what is she doing?
Signing for Mortgage Electronic Registration Systems, Inc.
Solely as nominee for GN Mortgage LLC. Okay, well, first of all, she's a Wells Fargo employee of the servicer. Okay, and again, as we discussed, the first assignment should have only been from GN Mortgage. So you know this is a fake assignment. If Freddie Mac bought the payment stream in 2005 as verified through the Wall Street records, we've already discussed an assignment of deed of trust memorializes a true sale of all three parts. Well, Freddie Mac bought this payment stream in 2005. What lawful package is she selling to her employer? She's assigning it to her employer.
She's selling some digitized paperwork without the inside payment stream.
She's actually just, what she's doing, she's trying to hoodwink the court, trying to just present something.
Is there a real person named China Brown?
Yes, yeah, she's a real person. Yeah, she's representing a number of different companies, different companies.
And is that her real signature? Do we know that's really her signature?
It doesn't look, she has different versions of signature. Lynn Zamoniak, who won the National Mortgage Settlement for the United States of America, has actually done a lot of research on this lady. And anyway, yeah, she's in a lot of hot water. It hasn't all caught up with her. But the bottom line is that this assignment of deed of trust does not memorialize a true sale. Again, if Freddie Mac bought the payment stream, what the heck is she selling to her employer, Wells Fargo? Actually, how it should have been is that in 2005, this is just a song.
This is 2010.
Yeah.
There should be something between 05 and 2010.
Well,
and there doesn't appear to be.
The items that made me realize that they did not abide by the state laws is where they sold the entire mortgage paper package is because PITE Duncan showed endorsements that just did not coincide with what should have happened. And then in addition, you had this assignment of deed of trust filed in 2010, whereby this defunct company, GM Mortgage or MERS, was selling something to Wells Fargo. Well, it's not a whole package because this payment stream was sold in 2005. So essentially, it's just not connecting at all whatsoever. So it's just evidence that they are trying to just hoodwink the court.
Hoodwink the court.
Yes. Okay.
Get away with the white-collar crime.
Right. Go down a little bit further here. There's a note from Lynn Zamoniak here for me. Okay, so let's go down here. Okay, MERS corporate resolution. Each company that's a member of MERS is given this corporate resolution. Okay, and let's just say that GN Mortgage did everything lawfully. Okay, they would have this corporate resolution giving them a right to file that assignment of deed of trust on a timely manner with GN Mortgage in there. Now, the fact is that Wells Fargo, they submitted their own corporate resolution. Okay, this is the wrong corporate resolution, number one, and it didn't click at all whatsoever because China Brown was signing for a defunct company or MERS, and actually MERS on their website is very specific in stating we don't participate, we don't sell, we don't sign assignment of deed of trust at all whatsoever. The OCC cease and desist order of April 13, 2011 told the industry and Wells Fargo, look, stop having your employees pose as MERS employees. That's an order. It is a violation, so stop it.
That was an order when?
That was April 13, 2011.
And they're still doing it?
They're still doing it.
It's 3 years later.
Mm-hmm. Yes, they're still doing it.
So they're violating an order. Is that order recorded?
It's the OCC. It's their boss. It's an agency that oversees them. But their attitude pretty much is we can do whatever we want.
Well, that's what U.S. Bank said in the Pam Ragland foreclosure, and they took her house right before Christmas in December 2008, and that's what's on Lopez versus Crooked Bank #2 on YouTube. Mm-hmm. And Judge Miller did not like hearing that Pam Ragland had a federal bankruptcy stay order in place saying you cannot take her house for 20 days. She has 20 days to come up with the money. They said, we don't care. And they took it the next week. And when Judge Miller heard her testify and saw the documents, they quickly settled out of court. Mm-hmm. That's why she can't come on my show and talk about it, because they paid her to shut up, and I'm sure they want that case. It was only 1 day's trial in front of the jury. I'm sure they want that sealed. Mm-hmm. They probably have applied to have that case sealed. But I was there and I saw it. I could see Judge Miller down there in Orange County was not a happy camper when they kept bringing up this saying, oh yeah, it was the arrogance of the attorney for U.S. Bank said to the jurors. You looked at the jurors and said, you wouldn't hold it against us if we just foreclosed on her a couple of weeks early, would you? I mean, she didn't have the money. You jury, you wouldn't hold it against us, would you? And the jury's like, is he kidding? Is he joking? You evicted this single mom and 2 kids right before Christmas, and we're supposed to sympathize with the bank? Because you broke a federal judge's stay order, and Judge Miller just let the attorney for Pam Ragland just hammer that when she started testifying. And they, the next day, said, we're done. We're not going to let any more get on the record. Pay the woman off. We're out of here. And they had 5 attorneys. And they were like, they couldn't wait to get this out of the, because I was there watching, and I was the only person from the public watching for my TV show. They couldn't wait. And I'm sure they were glad Judge Miller refused my media request, so I couldn't get any of that on videotape. Because now they can seal the court record, and nobody will hear any more about Pam Reagan. But because somebody tipped me off, she told me everything she was going to testify, and that's on Lopez versus Crooked Bank #2 on YouTube. So you can hear everything she said in court 2 days before she said it. Isn't that nice?
Yeah.
I would have liked to have had a camera in Mary McCullough's case up there in the northern state of whatever, Wyoming. Anyway, we're digressing.
Yes. Okay.
You need to stick
so,
here.
You
so
know,
we can get
one
done.
thing that I would like to just state in talking about judges, or just everybody in general, it's so important that we educate in this program. I feel that judges need to attend classes, and they need to show their competence, that they know how to form lawful mortgage-backed securities, because I think they're just winging it, and they're not educated on forming lawful mortgage-backed securities, and there's a lot of horrible decisions being made.
I agree, but you have Catherine Bauer, who's a former bank employee, now sitting as a judge, screwing over people in her court daily, and that's farther down south. In L.A., you've got Judge Korn, this real pretty blonde judge, and she was a former bank-related person, and she's sitting in judge and just hammering the homeowners.
Yeah, well,
So, I mean, even if they know, they seem to have a bias for the bank.
I'm not really sure what is going on. There was one judge that I was so proud of. His name was Samuel Buford, and he was in Los Angeles working the bankruptcy court there, and that man was just brilliant. He actually faced off with PITE Duncan, and PITE Duncan did not hoodwink this judge. He caught them on all their little shenanigans.
Good for Buford.
He was wonderful. Yeah, now he's actually working at the University of Michigan, I believe, or Michigan, I believe is where he's at. And I thought, you know, that's a great move, because he's educating the future attorneys on how to be a good judge in the future, or an attorney. So,
Do you think they forced him out of his office?
maybe.
Pressured him?
Maybe. I tried to call him, but of course I never got a call back. So, but he was wonderful, and I just would like to say that.
Okay, so we
yeah.
have one good Judge Buford, but he's gone. All right, what's the next point we have
Okay,
here?
so well, I think at this point now we're ready to go through the PowerPoint, so we can go ahead and.
Okay.
So here we go. Let's begin the journey. There are two doors here. We have the state of California door, and we discussed that, whereby anyone who is selling lawful mortgage packages, we must go through that door. And I like to liken this to, let's just say that we're at an amusement park and we're at the entrance, and one of the rules of this amusement park is you must go through the state of California door and complete all that mundane paper processing work in order to maintain that secured status of that debt
Okay.
to your paper note. Mandatory. You have to go through that door. And it's after that that you can go to Wall Street.
And what are those things they have to do in paperwork to go through the state of California door?
Well, again, so the borrower signs their paper documents. I put all their files together, and I will make sure that everything is perfected underwriting-wise, health and safety issues. And I drive to my seller's office, and we sit down and we look over all the files. He agrees to buy all of the files I have presented. I endorse the note over to buyer number B. And then I will then go ahead and record the assignment of deed of trust to represent our lawful sale of the paper documents.
Okay.
And then the monies then are forwarded over to me, and the public records reflect that assignment. So everything's been perfected within that 20-day window, whereby I have to file that assignment of deed of trust within that 20-day
So
window.
buyer B's forwarded the money over to you,
That's a lawful sale.
and that's a lawful sale.
Yes, so everything is still together. We have the paper note, and then my deed of trust have been sold together
Okay.
to the next seller.
Got the deed of trust and the note all together, and that goes to the seller.
Right, and then I
Seller.
record, yeah, and then I go ahead and record my assignment of deed of trust,
Okay.
which reflects that sale. We have perfected the sale.
Okay, so
Okay.
now it's a perfected sale, but it's
Yes.
all together, the payment stream, the paperwork, the deed of trust.
Right. Okay.
Got it.
Can we go to the next slide real quick? All right. I'm not going to go through all this. You can read this on your own, but essentially, I'm just going to give you an overview. Commercial Code 7-501, what this code is this is kind of like the chief and the director, which is telling all of us, you must buy and sell the entire paper mortgage package.
7-501 says there has to be a tangible paper mortgage,
Right.
not a digitalized
Right.
electronic.
So it establishes that you have to negotiate, transfer, and sell the entire mortgage loan package. Okay, all three parts. The
Okay.
paper note in its intact debt and the deed of trust and any applicable assignments of deed of trust. This is the boss, okay? Next, all right. Now, this banana, again, as we discussed, represents the paper note. And I liken this. So essentially what these people did is at the entrance of the amusement park is they said, you know what, we're not going to go to the state of California. What we're going to do is we're going to go ahead and strip the payment stream from the paper note, just like you would a banana. I'm going to convert this to a binary computer file, and I'm going to ship it out to Wall Street. I'm going to go straight to the Wall Street door,
Oh,
okay, with illegal electronic copies of the written negotiable instrument,
crime number 2.
okay? And we're going to form mortgage-backed securities. Now, because they did not go to the state of California door and went through that fiery door of Wall Street, they have just created unsecured debt.
And this is why they can't find the note.
Well, this paper note,
Got left behind or shredded.
it no longer evidences the debt, does it? Because this is in Wall Street trading.
Yeah, that's in Wall Street trading. There's the promise to pay there, but here's the note
And it had,
without the,
right,
they
without,
separate it. So now we've got a devalued.
it's a devalue, it's no longer new, it's nullified. Does it look like a good banana to you?
No, I wouldn't pay anything to buy a banana peeling
Right.
without the payment stream. So
Right,
that's why so many notes are missing, because they've sold that other valuable part.
yeah, this is a federal felony. When you sell unsecured debt with illegal electronic copies of the written negotiable instruments, that's a felony, 15 U.S.C. 7003. You cannot do that.
Who's guilty of the felony? The Wall Street guy that buys it that way? The person that sells it to them?
The individual that stood at the entrance of again, I like to use analogy of the amusement park that said, hey, we're not going to the state of California door, we're going straight to Wall Street. That is called an unsecured account debtor. And he used this item, which is personal property, his personal property, to involve his contract, his private contract.
Got it.
Okay, so essentially he should be chasing after himself. Instead, what he's doing is he's chasing after the homeowners, filing all these fraudulent documents in order to try to reconnect this debt involved with felony crimes back to these homes. He's toast.
If we catch him, if the sheriff understands that.
Yeah, it's too late. You can't put Humpty Dumpty back together again.
So no matter how many years have gone by, because of that fraud stops the statute of limitations. It could have been 10 years ago. We could still go get them.
Oh, absolutely.
And the homeowner can win their home back or the value of it.
If you understand the crime.
Or like Mary McCullough, get the jury to give her 5 times. She won $1 million in damages and $5 million in punitive damages. That's pretty good for catching them.
Right.
I don't know what Pam Raglan got now because she settled out of court and she can't tell me.
Right.
But I hope it was a lot.
I hope so too. I do. Okay, why don't we go to the next screen?
First step to forming lawful mortgage-backed securities. Carry out
Okay, well,
the task related to the paper mortgage
right. What
loan
again?
packages.
Let's not read over it because we want to go ahead and go over a lot of stuff. So what we're doing here is we're just discussing the fact that again, you must walk through that state of California door and negotiate, transfer, and sell that entire paper mortgage package. Okay.
Got it.
So I think everyone now sees that. All right. Proper endorsements, parallel assignments of deed of trust, which reflect that lawful sale that just took place.
Payment stream, the assignment deed of trust. Yep.
Okay, let's go to the next screen.
state real property laws, California Commercial Code 7501. You mentioned that earlier.
Right, okay, so again, this is just repetitive, but it's good to be repetitive so that we're clear on this
This
scenario.
is what people need to know.
Yes.
Even if
Okay.
their lawyer doesn't know.
So California Commercial Code 7-501, what did I say? That is the chief and director, right? It says that the paper package, all three parts, need to be negotiated, sold, and transferred with the parallel assignment of deed of trust and also proper endorsement. So there's not going to be blank lines, there's not going to be missing assignments, you're not going to have servicers pretending to be MERS employees or employees of defunct companies or ABC Trust from Wall Street filing assignments of deed of trust 10 years later. You're not going to have any of that if it's perfected and met the state of California laws, and that's required in order for any party to foreclose on a home.
912, I think?
9312.
9312.
93112 states that, again, that's the law that shows you that, okay, if you have a sale, you have 20 days of temporary status, but you make sure and record that assignment of deed of trust to memorialize that true sale of the entire mortgage package.
Which has got to be recorded in the county.
Right.
And the counties are getting cheated, so the district attorneys of the county should be criminally indicting these people.
Exactly. They've lost millions of dollars.
They've lost millions in every county.
Exactly.
And the taxpayers have to make up that lost income.
3203 subsection D. That law says, okay, well, you're at the amusement park entrance and you have two doors to walk through, the state of California and the Wall Street door. All right, well, if you chose to go ahead and walk through to Wall Street without going to the state of California door, you're toast. Because essentially what you've done is if you sold just a partial to Wall Street and did not negotiate the way you were supposed to with all three parts, then this note is devalued. It no longer is of any value. Use it for your birdcage. It's no longer of any value.
Or feed it to your guinea pigs.
Yeah, yeah. So yeah, you've just created an unsecured debt, and it's no longer negotiable.
So
okay, hold on one second. I just want to say something. The deed of trust secures the paper note. Okay, the paper note evidences the debt. If this no longer evidences the debt, the deed of trust no longer has anything to secure. So the deed of trust is null and void.
So the deed of trust is null and void. So it doesn't matter if the banking company or the service says, but we've got the deed of trust.
It doesn't, it's null and void.
It's null and void.
Right.
Once they strip that payment stream from
does it look of any value to you?
Yeah, no.
Okay.
No.
All right. We are at 3-115. Okay, this one talks about these notes that the third-party debt collectors bring into court with empty lines. That empty line is a negotiable instrument with a yet unnamed payee. And as we discussed, because a felony has been completed, this paper note with the blank line will never be filled in. Who's going to want to buy a devalued note?
Not me. I'm not paid for that piece of skin.
But that's what they're doing. PITE DUNCAN did it to me. They were waving in this note, and I tried to tell the Judge Kwan, I said, we need to get some accounting here. And he says, oh no, color of law. I'm going to go lift the stake, take her house. But that's what 3115 says. It says that if there's an unnamed payee, that negotiable instrument will not be negotiable until there is a named payee. And it will never be filled in because, again, you can't sell counterfeit securities.
Valerie, are you talking about the same Judge Kwan that sits in the Orange County Courthouse?
No, he sits in Pasadena now.
Oh, he's in Pasadena?
Yeah, he's a bankruptcy court in Pasadena.
Looks like then we turn to commercial code. Commercial code 3203.
Oh, C.
Subsection D.
Pretty much just saying that if you sell less than the entire mortgage note, then essentially it's not a negotiable, it's no longer negotiable, essentially. I just said...
Sale doesn't really become effective.
Right.
So why should the homeowner have to be foreclosed on if they've done this?
Well, actually, because of the crime, these people, these third-party debt collector attorneys, because they're so good at hoodwinking everybody and gift of gab, they have no right to exercise any state laws whatsoever, because essentially there's a felony committed. What felon do you know has a right to go ahead and exercise laws to make a revenue off of stealing properties? All right. Well,
State real property laws.
Yeah, this pretty much is just saying.
To be a holder in due course.
What I would dare any home. I'm not going to read through this. I'm just going to tell you. I dare any homeowner, when they're in court, to motion the court to require the third-party debt collector attorney to state, does he represent the creditor or the holder in due course? Okay, the creditor would be the individual that actually gave the homeowner money, or the holder in due course means that the transaction actually went through the legal process whereby an actual valid transaction exists. And he won't answer because he knows that the contract is breached and involved with securities fraud in the security market. He will not answer.
What if he does answer? What if he says we're the holder in due course?
Well, that would be pretty not so bright on his part, because the evidence in the public record shows that they never went through the state of California door. And then the missing
so then he's committing perjury on the record.
Right.
If he's sworn in. But most of these attorneys never swear in. They just come and argue.
Right. Yeah. Well, once you
So
understand.
is that one of the tricks? We have to trick the judge into swearing the attorney in under oath as a witness?
Well, my experience, Catherine Bauer, when I motioned Anglin Llewellyn, Dean Rallis to front up who he represents, he was like, "Oh, do I have to do that?" And she says, "No, you don't have to do that." So, anyway.
So she knew she was going to be caught in perjury.
Well, she actually participated in these little scams. So, she's just helping her buddies out.
Be the sole party with the sole claim to the payment stream. Debt, a.k.a. intangible obligation.
Well, this is just saying, again, you have to abide by the chief, 7-501. You have to negotiate, transfer, and sell the entire paper mortgage package. Okay?
I'm counting felonies committed by these white-collar criminals. I think we're at 3 felonies here so far. They've done all these things. So is there another slide?
Okay.
Mortgage-backed securities fraud.
Okay, so this is kind of a picture of what they did here. Essentially what they did is they said, we're not going to the state of California door. What we're going to do, we're going to skip the California door. We're going to go ahead and strip the debt from the paper note. We're going to turn it to a binary computer file, and we're going to send it over to Wall Street with illegal electronic copies of the paper note and deed of trust. And then we're going to go ahead and sell it to the unsuspecting investors. And we're going to grab their money, and no one will know. No one will know. And then what we'll do is we'll have the homeowners' monthly payment streams go and pay our contract involved with the securities fraud in the security market. And then if the homeowner defaults, then we'll steal their home because we'll hoodwink everybody.
Wow. This is massive white-collar crime, and this explains why we had the real estate crunch, at least in part, and why they needed a bailout. Because and if they made 100% copies, which is another felony, you cannot make a copy greater than 76% of the original wet ink original. If it's 77%, that's a felony.
Yeah, there is no law that allows what they did as far as making the illegal electronic copies of the paper note and deed of trust and then sending it over with a binary computer file of the debt stripped from the note without ever going to the state of California.
But there's nobody on the internet checking them as these things go electronically, whiz, 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 whiz in milliseconds. Who's checking them? Nobody.
And that's the reason why someone brilliant came up with 15 USC 7003 is because they said, oh, wait a second. We got to make a law here that they cannot make illegal electronic copies of the note and deed of trust, because if we have that over in Wall Street, they can sell it 10 times because there's nothing on record showing who actually owns that debt. So that's why it's illegal, and that's why I stood in that courtroom and said, no, I wanted to see the accounting. Because number one, there's a felony crime here, and I want to see where is my monthly payments going. I mean, I go to work every day.
Did your judge or your crooked judge order them to provide the accounting?
No, both Catherine Bauer and Quan and Ferguson were protecting them, and including the BAP courts also were protecting them.
Ferguson too?
Ferguson, yes.
He was on Obama's appellate court in the 9th District Federal. I was there. I was watching him. He was one of the 3 judges that finally said, we don't have authority to decide whether Obama was illegally elected.
Well, now we don't know why.
Well, I guess we do know why.
Yeah.
The different puppets, but the same puppet masters are the Wall Street bankers.
Right.
They're getting away with white-collar crime. I don't think anybody's ever stole this much.
But not anymore, because I think that now that we all know, we're not going to stand. I mean,
This makes Jesse James look like an ant.
I mean, but the bottom line is, again, they need to understand they are our equals, and they have no right to do this to us.
How are we going to hold them accountable?
What can we do? Understanding the crime. We need to thoroughly understand the crime. And we need to start educating our law enforcement as well. And also, we need to stop saying that it's a civil issue. It's not a civil issue. It's a very serious felony that's been committed. We shouldn't be losing our homes. It's a federal RICO. It's an organized crime. What is happening is the servicers, they may own maybe some part of the unsecured debt involved with securities fraud, but that's about it. But because it's a security, it's non-recourse. Like any stocks that you buy, if you lose your money, it's like playing Las Vegas. You lose your investment. Same thing. Anybody that bought that unsecured debt, they can't access our homes. It's unsecured debt. It's a felony. It's breach. It's
so you could file a bankruptcy Schedule F and get rid of the mortgage loan as an unsecured debt. Unsecured debt once you find that they've committed these felonies.
Yeah, and don't get pushed around by the judges like I was.
Well, I don't think you got pushed around too much because you're still fighting.
I'm still fighting, right? Yeah, I know, but. Yeah, but they're really good at convincing other law enforcement agencies, oh, well, you know what, I'm the federal judge, so I'm going to allow them to take her house.
Yeah, well, I saw that happen with Teddy Sheldon's house, too, and she didn't even have a bank loan.
Yeah.
They took her house and was free and clear, and they took her house.
Yeah. So, you know, another thing, too, on there, I think that I discussed also public banking. I think that we should work together to form our own public banks.
You mean a state-owned bank? A state central bank?
Yes, owned by the people.
Well, North or South Dakota has one of those, and they've been making loans, and they're not in the trouble the Federal Reserve is.
Right, and what I think is, you know, as you know, most of these banks, what they do is they monetize, whether it's a car loan, a credit card application, it's like 10 times the face value. So if we had our public bank, what we could do is we could take some of those monetized funds and reinvest it back into community and education, definitely. We need to get people more educated to build the skills necessary to get our economy up and running and viable businesses. So I think that's about it. And at this point, I think I'd like to bring on Joe Esquivel, who...
Well, now we're getting to forensic audits, right?
Mortgage compliance investigators.
Right.
Joe is a private investigator that understands this crime very thoroughly.
So if you're a homeowner and you suspect, because you see the original note and you see a blank line, or you got a trustee and there's no person in there. So what would you estimate? 20% of these banks are engaged in fraud, 30%, 50%, 60%?
I would say that probably 97%.
97% of the loans could be eliminated if the people just asked to see the original documents and brought a investigator who's qualified to do it? Is that what we're saying?
Well, you would want to definitely look to see the path of your payment stream and look at the public records to see whether or not it adhered to the state of California requirements. Esquivel.
Esquivel, a call.
Hello.
Hello, Joe Esquivel. This is William Wagener on a live broadcast on television in Santa Maria, California. Could you tell us what you do, Joe?
I'm a licensed private investigator for mortgage compliance investigators, and I deal with issues pertaining to chain of title.
And when you find the chain of title has been broken, do you write a report for the homeowner or give them an affidavit?
We do reports for homeowners, HOAs, investors. We do reports for all different types of people.
And do you give them a report or an affidavit that'll stand up in court?
Well, what we do is a little different. I mean, what I put out is an analysis. It's an educational analysis, along with a factual affidavit.
Okay.
Because the factual affidavit states my findings. You know, I have looked at a note. Okay. I see an endorsement from party A to party B. I look at this note. I see an incomplete stamping as well from party A to an as of yet unnamed payee. I look at a document in Orange County purporting to be an assignment of deed of trust from party A to party B. So the actual affidavit is a factual affidavit stating facts of the documents that I look at. The analysis and investigation that I do lays the foundation in which the parties can start any action that they wish to take.
Excuse me, would you recommend a quiet title action?
When? You have to understand, quiet title is both a remedy and a cause of action. Many people have a misunderstanding that they file a quiet title action and it's a silver bullet that fixes all, but they really have no idea of what they're doing. Why would you file a quiet title action when a third party has a color of title claim on your property? In my opinion, better to get a status quo determination as to the status of these parties prior to going after quiet title. And I would do that in the form of possibly a declaratory judgment, all right, as to having the courts determine, does this party have a proper claim to rights to title to my property? Because color of title is not the same as legal title with legal rights.
Right.
Big difference.
How long does it take you? I mean, we can't mention what you charge for it, but how long does it take you? Once, say somebody comes to you on the 1st of January and says, you know what, I'm not being foreclosed on, but I just had my loan traded 6 times last year and I've sent it to 6 different people and I'm not sure I really have to pay them. Now, they're not in foreclosure. No one's filed a notice of default. And they come to you on January 1st and they give you the whole copies of everything they've got, and it's a complete copy, but not the original. How long would it take you to read through that? How many hours before you would come up with a report and possibly an affidavit of wrongdoing?
Our turnaround time is about 10 business days. I mean, there's a lot of work involved, but you have to understand what you're asking. And when you're stating that, the loan has been sold 6 times, you need to, understand what is a loan. Because a loan, we talk about the loan instrument, which consists of the tangible promissory note, which evidences the debt, which is the intangible payment obligation.
Right.
Right.
The banana inside the paper stream, yeah.
Correct. And then, and also we need to be talking about the security instrument being either a mortgage or a deed of trust, or if you're in the state of Georgia, a security deed, all right, which attaches to the obligation, which is evidenced by the tangible promissory note, because you need to have all 3 in order to be a holder in due course. There's a misconception when they say, well, my loan's been sold, or, there's an assignment. Well, what is an assignment? The purpose of an assignment is to memorialize the transactions pertaining to a negotiable instrument in the acquiring of rights. It does not cause the sale. The sale is caused pursuant to statutory requirements of law. So when you look at all of these documents, all right, when UMTW falls off the wall, you cannot put them back together again, and that's what the banks are attempting to do by filing such documents into public record. But when you file these documents into public record, all right, I mean, there's many laws that are being broken. You have 11, just a plethora of violations. I'm not even going to get into. But it's the act of recording this document that is no longer, that was never eligible to be recorded. All right? Because when you record something into public record, all right, it's an act of recording that document where you're slandering many times the title of a party that has legal title. That assignment of deed of trust, for example, in California, they're putting a claim to title to this property. They're saying, hey, we're doing an assignment of deed of trust. And then, in a little forefont, it says together with a note and all obligations due. But the problem is that if you understand what this document actually said, and that you understood that they cannot, all right, do what they're stating. So they're defrauding public record, and then they put these documents into court, all right, and they're defrauding the courts. All right?
Yeah,
Many times you've
fraud,
got parties such as murder.
yeah, fraud on the court is considered generally by most legal scholars to be worse than murder, because it devalues the credibility of the entire court system. Where a murder of one person doesn't devalue the entire court system, but fraud on the court. But from what I'm seeing and what I'm observing is there is massive fraud on the court happening all over, and
But it's not brought forth properly. That's the problem, right? Because for you to just make a statement of fraud, right? And people do it all the time. Oh my God, Joe, I got wrong foreclosure. Well, sorry, it's not a proper cause of action. If you're going to state fraud, all right, and even if you are a pro se litigant, or if you're an attorney, all right, they're making mere allegations, all right? And right now, all right, with the stricter requirements for heightened pleadings, all right, if you're going to state fraud, cite all 5 elements of fraud. Cite A, a false statement of material fact. B, knowledge on the part of the defendant that the statement is untrue. C, intent on the part of the defendant to deceive the alleged victim. D, justifiable reliance by the alleged victim on the statement. And E, injury to the alleged victim as a result. With specificity and particularity, if you can't cite this, don't state it.
right.
Because they're going to throw it out.
So you have to state that in your motion that you file,
In
and
your claim,
in your claim, and you also
your
have to
cause of action. Right.
you have to have your attachments to prove each element.
Right. I'll give you an example. Okay, so if I'm going to cite, say, a particular document, all right, with mine, for example, okay, there's a document pertaining to, purported to be an assignment of deed of trust dated blah, blah, blah in the official records of blah, blah, blah. Okay, county recorder's office. Well, that is a communication of a third party of a false statement that's derogatory to the plaintiff's title, and it's made with malice causing injury to the plaintiff's claim of title. All right, and then I go into what makes it. How does it fit into the elements of fraud? Well, let's see, the statement in county record is in a document purporting to be an assignment of deed of trust dated, whatever date, stating that MERS could assign the note or notes described or referred to, and that's a false statement of a material fact because MERS knew or should have known that it could not assign the note pursuant to statutory requirements of law. MERS was never the owner of the note. MERS intended to deceive in public record that it could assign the note. And the plaintiff and the public relies upon public record to know other claims of title. Now, as a result of the MERS false statement, the plaintiff's claim to title is devalued.
That's what Valerie LOPEZ was saying.
Yeah, so now, go into the actual MERS documents. When you go into the MERS documents, many people, if you read what MERS says, okay, if you understand MERS in their own documents, all right, go into the MERS procedure manual, which is version 19.0 and is dated June 14, 2010, page 63. It states, transfer beneficial rights to member investors. Overview. Quote, although MERS tracks changes in ownership of beneficial rights for loans registered on the MERS system, MERS cannot transfer the beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to the transferee. Okay, now you can also go to the MERS residential marketing kit, right, in which there it states under the terms and conditions. MERS shall have no rights whatsoever to any payment made in an account of such mortgage loans, to any servicing rights related to such mortgage loans, or to any mortgage property securing such mortgage loans. MERS agrees not to assert any rights. The MERS system is not a vehicle for creating or transferring beneficial interest in mortgage loans. Now, go further with that pursuant to the maximum of law, nemo, dat, quod non habet. One cannot sell what one does not own, but yet they do it all the time. So you've got a lot of hypocrisy going on. And the problem that we've had many, many times is that the parties do not, the homeowners, the attorneys, do not bring forth complete arguments. I mean, just look to Nevada. Look at MERS versus Edelson. You had an attorney that brought incomplete arguments, and they did it, and they just paused halfway. They went to a gunfight with the bottleneck, and they got their butts kicked. Because we're relating, to the courts, and all we're citing are citations, we need to go to statutory law. Don't go to common law, go to statutory law. Many times you hear, well, you know what, Joe, the mortgage follows Carpenter v. Logan. Has anybody ever done their homework? Do you realize that Carpenter v. Logan was done in 1872? All right? We didn't have the Negotiable Securities Act until 1881. All right? That act was based on common law, not statutory law.
You mean 1981?
1881.
1881.
Right. Carpenter v. Logan was 1872. All right? The Negotiables, all right, Instrument Act was 1881. All right, and then Uniform Commercial Code came in 1961. And then all of the states have their own equivalents to that. All right? So California has their own state's equivalent to the Uniform Commercial Code. Nevada has their own. Florida has their own. So, if you're in California, you go to California Commercial Code. If I'm in Florida, I'm going to go to Florida State's, code under 673 for, say, negotiable instruments. If I'm in Texas, I go to Texas Business and Commerce Code. So depending on what state you're going to, you use your state's equivalent to the Uniform Commercial Code. So many times, everybody is citing citations that are incorrect. I say, go back to statutory law. Go back to what the statutes say. The statute says you can do this, you can't do this. When you're talking about title, when we're talking about property, right? We're talking about a tangible instrument. We're talking about a note. Right? We're talking about the debt, which is evidenced by this tangible promissory note.
Joe,
When
have you seen attorneys bring in the wrong law into court? Have you seen it with your own eyes?
Time and time again.
So
Time and time again.
people should not rely on just any attorney they find to file correctly to get their house free of these fraudulent mortgages.
Well, it's not free of fraudulent mortgages. All right? If you understand, the act of foreclosure, all right, is an attempt to collect the debt. That's what it is. All right? So the banks lose an alternative means of collection. There is no such thing as a free house. All right? There's a loss of an alternative means of collection. That is the purpose of the deed of trust or the mortgage, an alternative means to collect a debt. All right? But it must be properly secured to the obligation that is evidenced by the tangible promissory note.
But once they've separated the payment stream from the note or the assignment of trust deed and electronically transferred it, they've devalued the note. So what other way do they have to collect the debt once they've destroyed or devalued the note?
Well, you have to understand, you can sell the debt all day long, and that's under Article 8. All right, you can do that. Imagine if you have a strip shopping center, okay? I'm in LA, all right, and I've got a strip shopping center and I've got 10 stores. And I've got tenants in those stores, and I'm falling behind on my bills. And I don't know what to do. And suddenly I wake up one night and I have an epiphany. Wait a minute. I've got leases. Guess what? I can sell the leases. The leases are a right to collect future monetary obligations. All right? Now, you sell those leases. You still own the strip shopping center. Okay? You've sold the right to collect future payments. Look at credit card debt. You hear credit card debt, student loans, fleet leasing. All right? They sell the debt. That's legal. All right? The problem is that if it's not properly evidenced, all right, is it properly secured? Was there a UCC-1 finance statement filed with the Secretary of State? Was there a proper party in public record? No. Registration System Incorporated is an electronic registration database. That's it. It is not, they perceive it to take the place of county recorders, but yet every time someone does a sale of real estate, what happens? You have closing after closing, they take the papers from title and they go file them in county record. Right?
Right.
If we're going to continue to use county record in the county recorder's office, right, what the hell are we using MERS for? It's just about greed. It's about a false illusion of what it purports to do.
Got it.
Just because you file a document in public record, all right, that act of filing it in public record does not cause a transaction.
Okay, Joe, you want to go through the graphic now?
Sure. Yes.
You know what?
One more thing.
Joe, can you hold on 1 second? There's two things that you need to cover like in 15 minutes. The first thing is the infographic, and then also a lot of people are interested in your knowledge regarding bankruptcy, taking the unsecured debt through bankruptcy, and then also 11 U.S.C. 524A2.
Okay, well, first off, you have to understand, in bankruptcy, the whole purpose of bankruptcy, in my eyes, I'm not an attorney, I'm not giving legal advice, but bankruptcy is to give someone a fresh start. All right? So, if something, right, I use me as an example. All right, so if I discharge a debt, all right, one, you have to understand, when you file bankruptcy, right, you have a set of schedules in which you put your property. Right? So when you put your property in there, you have determination of, you list whether your property is secured or unsecured. Well, just looking at the bank rules, it says, all right, pursuant to BK Rule 3001, subsection D as in dog, all right, that any party coming forth with a claimed interest in a security certificate or a security instrument must be evidenced by a properly perfected lien. How does one properly perfect a lien? By filing into public record. Well, let's see. Is Fannie Mae named a public record? No. Is Fannie Mae named to the note? No. Yes, they're not a properly secured party. I'm going to put them on Schedule F as in blank, unsecured, non-priority. All right? Now I go and I get my debt discharged. All right? Under Title 11. All right? I'm going to go get my debt discharged. All right? And when I get the debt discharged, okay, the debt, all right, now has a zero sum, all right, that is owed, right, because they say, okay, yeah, you discharged the debt. All right, the problem is that many times in California and other states, they still come forth and do a notice of default. Well, wait a minute. I've discharged this debt that was evidenced by the tangible promissory note. When I've discharged that debt, there's a zero sum due. There was never a properly perfected lien, because a properly perfected lien will survive a bankruptcy. All right? So that court order, all right, is an injunction of federal court. Now, if you look under 11 U.S.C. Section 524A2, and that's under effective of discharge, which states under A, a discharge in a case under this title, let me go to 2, says, operates as an injunction against the commencement or continuation of an action, the employment of process, or an act to collect, recover, or offset such debt as a personal liability of the debtor, whether or not the discharge of a debt is waived.
Okay.
So they're violating this injunction when they're filing an NOD and coming to foreclose, because foreclosure is a form of collection of debt that no longer exists, that has a zero sum due. So now you also have slander of title, you have fraud, and you have violation of 11 U.S.C. 524A2.
How many felonies is that? Joe, how many felonies is that?
I'm not going to say, again, I'm not an attorney, but I recommend somebody to,
take
do
a
your
guess.
diligence like I do.
Take an educated guess, Joe. You're entitled to take a guess. There's freedom of speech. We only got 6 minutes left.
Well, you're looking, again, you've got slander of title. You violated.
One.
You violated violation of the bankruptcy injunction, and you have fraud. All right, and then you've got 15 U.S.C. Chapter 47, 1021, all right, which states anyone who knowingly records or does not record a document, all right, which we know that they knew they recorded a document which they did not have the authority to record. Thus, the act of recording that document slandered the title to the property. I mean, you've got a number of you had.
So that's at least 4 felonies. We're looking at least 4 felonies by the white-collar bank criminals. And yet the homeowner doesn't know any of this because they haven't done a forensic audit.
Well, it's not forensic audit. I mean, forensic, you're going to numbers. And analysis is what mortgage compliance investigators does. You know, we do an investigation and analysis pertaining to whatever state you're in.
And you get it done in 10 days or thereabouts.
Approximately 10 business days is what we do.
Okay.
And again, you know, these infographics that you have up, you know, we've created a number of them. So in layman's terms, if you look at the one that you have up, which is, I believe you have the RMBS one up right now, Valerie?
Yes, we do. I think, do we have the camera on it? Yeah. Okay.
Yeah. All right, so take a look at it. And again, this is very basic. So then when you're looking at it, we're starting off, and we've got the borrower, John Doe. That's in the blue box. Okay, and he signed a closing. In this instance, I just put an arbitrary date up there, October 24th of 06. So you have the Doe note and the Doe mortgage, or deed of trust if you're in California. All right, now, after closing, all right, the note is sent to county recorder's office, where it's recorded, indexed, filed. All right?
Right.
And then, now after that, they send it back to the lender. All right? Now at that time, you have a properly perfected lien. All right? And the lender or originator, right, scan into a system. All right? And then many times they put a stamp on it that says page the order of an as of yet unnamed payee. Right? Now, at that time, the intangible obligation is ripped out and sold. And it's sent to a sponsor, if there's a sponsor, depositor, right? Depending on what the PSA says, the pool and servicing agreement. There's a number of transactions that must take place in order for this to be into a RMBS, residential mortgage-backed security. All right, so in order for this to be a RIMIC, a real estate investment mortgage conduit, and fall under the IRS code under Title 26-860D, all right, certain things must happen. There must be 2 transactions out, 2 on-site sale transactions, all right, the trust, all right, prior to being able to act as the trust must have all the assets in it by the closing date. That is in IRS publication 938. IRS publication 938 is the publication that is filed with the IRS. All right, when they set up their RIMIC to do business, they put it into public record. Hey, IRS, we want to be a RIMIC. Right? We want the status where nobody has to pay taxes until it goes to the certificate holders. So we get all of these tax loopholes. And then it's filed in the SEC if it's publicly traded, right, on the secondary market, right? And that's where you have the 424B5 rule. And it goes into a prospectus supplement. And where it states, you know, all the assets will be in there by this date. Now, what many people have a misconception of is that the note will be in there, right? Read the PSA is what I tell the people. Because if you read the PSA, it says, okay, the sponsor shall sell to the depositor. The depositor shall sell to the trustee. And they name these parties within the pool and servicing agreement. So in this example, it says originator, Nation Point. The sponsor is Merrill Lynch Mortgage Lending. The depositor is Merrill Lynch Mortgage Investors. The trustee is LaSalle Bank. Now, what they are doing is ripping out this intangible payment obligation, and the intangible payment obligation is being sold electronically. And while it's being sold, they're using swap certificates from party A to party B, because many times you'll see within the pool and servicing agreement that says the sponsor shall own no assets. The depositor shall own no assets. Because they want to keep themselves bankruptcy remote. intangible payment obligation, as done under Article 8. Right? Because it says the assets must be in the PSA. And if you actually read the PSA, it says, the deposit shall sell to the trustee its interest in these loans. Well, the interest was a intangible interest, and he sold that interest. Did it comport with statutory law? No, not always. Right? But, again, this is what the banks have done. They wrote these for the benefit of the banks. They didn't write it for John Doe that was investing in it. The whole purpose of these RICs is to have a special purpose vehicle where multiple different types of investors can invest in. Right? So they have 20 or 30 tranches, and they have 3 or 4 groups within this RIC. So what that means is that you can have multiple different types of investors all investing in this one trust. So depending on what sort of investor, if you want to be a conservative investor, then you're going to invest in, say, Group 1, meaning that you're going to get a set amount, all right, every month, and it's going to be, say, 3% of all the principal and interest for, tranches 1, 3, and 5. And you're going to get that set amount every month. And if you were to say Group 2, all right, you may get a different rate, and you're only going to get, all right, principal interest is going to pay more, all right, but there's more risk associated with it. And if, say, you're in Group 3, all right, which is the junk or the mezzanine, all right, because you get paid last, all right, it is these classes, all right, which support the senior tranches. They get paid last. And they may only have a shelf life of, say, 1 year, 2 years, 5 years, 10 years. And
Wow.
this is where many times when someone would look at a Bloomberg screenshot and say, oh my God, Joe, there's 30 tranches, 5 of them are paid off.
Got it.
Loan's paid off. No, your loan wasn't paid off. The tranche was paid pursuant to the underwriting agreement and the pool and servicing agreement. Underwriting pertains to the prospectus supplement.
Joe, we got 1 minute. We got 1 minute left to summarize.
All right. Securitization is legal. The problem is it was never done correctly. You need a chain of title analysis in order to get it done correctly. That's what mortgage compliance investigators does. If you have any questions, you can call mortgage compliance investigators.
Can I give out a phone number for you?
888-491-3741.
Thank you very much, Joe.
Thanks, Joe.
Appreciate you calling in.
All right. Have a great evening. Thank you.
Thank you. Well, people, you've heard it from Valerie Lopez, who used to have her own business. Now you heard it from a investigator who specializes in it. If you have a home loan, whether you're in foreclosure or not, wouldn't it be a good idea to check and see if they've committed fraud?
Oh, absolutely, especially with so much going rampant right
There's
now.
so much rampant fraud and so many crooked judges looking the other way. You need to know if your crooked judge is going to screw you before he comes up for re-election. So we need to do this. The R.I.C.O action, that's a whole nother show, Valerie. We're going to have to do that at a separate time because we're just about out of time, people. Valerie, I want to thank you so much.
Thanks for having me back.
I'm so glad you came back.
So am I. My bananas.
You got bananas? We
Yeah.
got guinea pig banana food here. I just love this cartoon by BizarroComics.com, you know. This justice system, if we could flash this up again, this is, you know, one guy's asking, how much does the justice cost? The guy's at the vending machine saying, hey, just keep putting money in until you're broke and hope for the best. And people, I didn't get to ask Joe, but I think I would recommend before you hire an attorney, hire an investigator to look at your paperwork, the complete package, if the bank can even give you a complete package. And what I didn't get to ask Joe is if an affidavit of lost note is the same as the real note. Does that suffice? It's like, do I have a Xerox copy of a $100 bill? Is that as good as a $100 bill? I don't think so. What do you think Joe would say?
Oh, absolutely not. He would, yeah, he has something to say about it. We need to get him back.
Yeah, we just didn't give enough time to cover all the bases. But people, a lot of you are losing your homes, and I hope you paid attention tonight. You got the number there, Joe, and if you want to see the show again, look for it on YouTube. Today is December 5th. Yay. Thanks for watching. We'll be right back.